This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about the Freedom of Information Act and why res judicata foils the demand of a convicted medical fraud felon who sought a second attempt to obtain disclosure of FBI records after his conviction and sentence and service of time, because a healthcare fraudster seeking FBI records for the second time after serving his time in jail to use that information to punish others because he was caught committing fraud. Serving time, the court made clear, in prison doesn't give a fraudster a right to FBI records that he had requested and did not obtain the first time he tried. The United States Department of Justice Federal Bureau of Investigation moved to dismiss plaintiff's complaint. Pursuant to Rule 12 of the Federal Rules of Civil Procedure, Plaintiff Joseph Mermelstein brings this Freedom of Information Act action seeking records from the Federal Bureau of Investigation. In Joseph Mermelstein v. the United States Department of Justice, the New York U.S. District Court for the Eastern District of New York on October 1, 2024, resolved the motion. In July of 2023, plaintiff submitted a FOIA request to the FBI for, quote, all records, close quote, relating to the plaintiff. Through the 2023 request, plaintiff seeks production of records relating to plaintiff's indictments and convictions in federal court for medical insurance fraud for which he was incarcerated until 2015. Specifically, the 2023 request seeks records that included any conversations between plaintiff and another named individual between October and December of 2025. Plaintiff previously filed separate FOIA action against the FBI in 2019, Mermelstein versus the FBI. On appeal, the Second Circuit affirmed the district court's summary judgment in favor of the government in a case of April 18, 2023, decided by the Second Circuit Court of Appeal. The FBI moved to dismiss plaintiff's claim on the basis of res judicata because the matter in controversy had already been adjudicated. A party cannot void the preclusive effect of res judicata simply by asserting a new theory or a different remedy. To prevail on a claim of preclusion being brought by the FBI, a party moving to dismiss must establish 1. A prior final judgment on the merits, 2. By a court of competent jurisdiction, 3. In a case involving the same parties or their privies, and 4. Involving the same cause of action. The parties do not dispute that Mermelstein 1 involved a final judgment on the merits by a court of competent jurisdiction and involved the same parties as the action presently pending. The question, therefore, was whether the cases involved the same cause of action. The FBI contended that plaintiff's complaint in this action is merely an attempt to relitigate the same issue that arose in the prior action, the adequacy of the FBI's search in response to his 2018 requests. The court was satisfied that it may judicially notice the public docket filings in Mermelstein 1 to aid in its evaluation of the defendant's preclusion challenge. To assess whether the causes of action are the same, the court looked to whether both lawsuits arise from the same transaction or involve a common nucleus of operative facts, and on their face, the requests were not identical. The 2023 request arises out of the government's criminal prosecution of plaintiff for fraud, on the basis of which he was convicted and sentenced to prison until 2015. The complaint in the prior action lists identical facts, and since there were identical facts, the causes of action are therefore the same for purposes of claim preclusion. As a general rule, newly discovered evidence does not preclude the application of res judicata. Only where the evidence was either fraudulently concealed or when it could not have been discovered with due diligence in the prior action will exceptions to the general rule apply. Inconsistencies proposed by plaintiff did not indicate that the FBI fraudulently concealed the 2005 records. Instead, plaintiff merely noted that he discovered gaps in the responsive documents that could have been raised in the prior litigation. The USDC noted that the plaintiff provided no support for his attempt to reopen that litigation in order to address an issue raised by another litigant in another forum. To the extent plaintiff attempted to continue litigating the sufficiency of the FBI's search, his claims were barred. Therefore, the USDC granted defendant's motion. Plaintiff's complaint was dismissed in its entirety with prejudice. In my opinion, health insurance fraud, the crime for which the plaintiff was convicted and served time in prison, is very profitable. As a result, the convicted felon had sufficient funds to retain counsel, to attempt to gain information from the FBI, to use that information against others who may have been responsible for his incarceration. The FOIA requests were precluded because he used the same requests in litigation to use the information obtained or obtainable to defend his criminal cases. He lost in the USDC and in the appellate courts, and his attempt to redo the entire action was rejected appropriately as res judicata. This video was adapted from my blog, Zalma on Insurance. Is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 4,900 blog postings. You can also subscribe to these videos on YouTube and rumble.com. And if you do, I'd appreciate it if you click on the like button at YouTube or on the thumbs up button at rumble.com. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in further information about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.